today because a pet has died under terrible circumstances. We sympathize with Mr. Mafhume's loss, and him having to relive these emotions during this trial. Quick summary of the facts. Pi was injured by the plaintiff's garage door after getting a surgery at Tender Care Animal Hospital. Because of those injuries, Pi seemed to react badly to the medication he was prescribed, but was given by Mr. Mafhume regardless. After 5 days, Mr. Mafhume brought Pi to the emergency room, where Pi was turned away by the technician with another drug prescription. Upon return to Pink Pearl emergency room, the plaintiff found out from the veterinarian this time that Pi was in kidney failure. Mr. Mafhume opted for euthanasia. What happened was awful. However, my clients, Tender Care Animal Hospital and Dr. Amelia Philopoulos, are not responsible for Pi's decline in health nor death. Furthermore, the plaintiff, as well as Pink Pearl emergency room, are negligent in this case. First, Your Honors, my clients urgently performed treatment the day of care. They successfully performed the surgery, and they provided Mr. Mafhume with directions to monitor Pi while on Medicaid, the medication that was prescribed after the surgery. Today, the plaintiffs pointed out that Dr. Philopoulos is not a boarded surgeon and that her assistant is not licensed. However, as I'm sure you've already gathered, those two are absolutely irrelevant because no evidence was presented to show that either of those things impacted the treatment nor the prescription of Medicam itself. Now, focusing on Medicam, my clients were just doing their job. Dr. P told you today that she successfully used Medicam on cats for nearly a decade. She looked at the blood work by the Humane Society, which showed nothing abnormal. She pulled a cystosynthesis and urine for analysis that showed nothing that could say that Pi could not handle the drug. Her using the older version of Plum's guide, that is just a guide, not the law, which rarely changes additions. Using body weight instead of lean body weight was not negligence, because even Plum's guide, which the plaintiff referred to, does not even mention lean body mass. But even if there was evidence, there is no evidence to show that Medicam was the cause of death because no necropsy was done. But even if there was, my clients gave Mr. Mafhume warning to monitor vomiting and stop Medicam if needed, which he failed to do, and therefore is negligent. You may feel that my clients gave insufficient warnings because Mr. Mafhume did not receive the slip explaining Medicam. However, the warning to monitor vomiting was bold on that medication that was given to Mr. Mafhume. And Tender Care Animal Hospital even trains its technicians to repeat those warnings orally. So my clients are not negligent.
Counselor, but where was the witness who said that they actually gave the warning? It seems like a massive hole that if you're alleging the warning was given,
I am not alleging
the burden of, wouldn't you be the one who has the burden of production to produce a witness to say, I gave the warning?
That's correct, Your Honor. We do not have a witness to support that assertion. However, I am just merely making the assertion that the practice of the Tender Care Animal Hospital is that they normally train their technicians to give those warnings orally.
Counselor, you had your client testified that she had expected her vet tech or the person who gave the warnings and the instructions to provide the warnings appropriately, but your client didn't actually tell the Pi's owner to about the warnings herself, did she?
That's correct. There was a bold warning on the medication, and as far as Dr. P's involvement in this, she has successfully used Medicam on cats. So her normal procedures have worked very successfully for nearly a decade.
But didn't she have a phone conversation with Pi's owner after the surgery and tell him exactly what she would be prescribing him?
I do not recall that at the moment.
I believe that your client did testify that she had a phone conversation after the surgery, but at the time she didn't actually give the warnings herself over the phone. Isn't that true?
That's correct.
And she's the one who's the veterinarian who prescribed the medication, correct?
That's correct.
So wouldn't it be reasonable during that phone conversation to give those warnings directly to Pie's owner?
We disagree, Your Honor. We think it was sufficient that there was a bold warning on the medication itself.
And that warning actually didn't say anything about nausea, did it?
No, Your Honor, but Dr. P even mentioned herself today that vomiting and nausea, those two go hand in hand. Mr. Maffium today testified himself that he knew that the cat licking lips was a prelude to vomiting. So he had all reasonable knowledge to know that vomiting and nausea are very well intertwined.
Counsel, do we have any photograph of the warning that was given to the plaintiff?
We do not.
Okay, thank you.
So as we continue, I'd like to again reemphasize the negligence of the plaintiff in this case. He again did not stop giving Medicam when he was supposed to. He had knowledge to monitor vomiting. He witnessed Pie nauseous, but he continued to give Medicam. We see that Dr. P testified herself that he should have stopped on day 2 when he witnessed this nausea. And Dr. Volpes from the plaintiff today mentions that if he would have stopped on day 2, there is no way that Medicam would have been the cause of death. As we look at Pink Pearl Emergency Room's negligence in this case, we look at that first visit when they were sent home without Pie even being looked at a veterinarian. The technician, upon arrival, looked at Pie, decided the situation was not emergent, and prescribed another drug and just sent them away. Dr. Volpes from the plaintiff today says that this behavior was inappropriate for the technician to do, to diagnose Pie without him being seen by a veterinarian. Moreover, Dr. Volpes from the plaintiff again says that it is possible Pie would have been saved if Pink Pearl Emergency Room had not sent them home that day. This is proximate cause to the reduction in Pie's chances of survival. And lastly, I would like to touch on damages if your honors are ready.
Are you just conceding then that he's the owner of the cat?
Yes, the defense decided to drop that argument for the fact that Mr. Maffium did pay out of pocket for the surgery for the Pink Pearl Emergency Room. He did make monetary contributions to the cat. So we did, out of respect for Mr. Maffium, decide to drop that ownership argument.
Okay, you do know that someone, yeah, I hear you and I take your concession, but someone can't get damages for property that's not theirs. They might get reimbursement for expenses they've incurred, but you can't get damages for property that's not yours. I heard in the testimony that the adoption contract was approved and finalized 3 days before the cat died. But my understanding is that the negligence occurred 5 days before the cat died. So in my hearing the testimony, the adoption contract wasn't finalized and approved until that would be 2 days after the negligence. But you've conceded it, I understand, but it's out there as an issue that one could theoretically say he has no standing.
I understand that, Your Honor. As far as I believe, the contract was signed and finalized 3 days before Pie's death, which would be when Pie started experiencing those symptoms of Medicam. He started developing that nausea, because on the 5th day, that is when he was actually brought into the emergency room.
But when is the negligence then? When's the misconduct occurring? Is it when Pie is taken in and given the medication, or later when Pie develops symptoms?
The defense believes that the plaintiff is asserting negligence when Pie is actually reacting bad to the medication. That is what they're asserting. my clients should not have done, should not have given that medication, should have given it sufficient warnings to show that nausea, would have prevented.
But wouldn't that be on the day they actually give the medication? Not later when the cat develops adverse reactions?
Yes, that may be true.
Okay. Please continue.
So as we look at the damages, the plaintiff today mentions that they are seeking well over $25,000. There's no specific amount, but the defense would like to just break that down. Although we're very confident that my clients are in no way liable in this case, we'd still like to touch on damages. So we're looking at 3 different evaluations for value of pie specifically: market value, replacement value, and intrinsic value. When we're looking at market value, we see that pie was going to be adopted for $100. However, he was never owned, and his value was well reduced after the plaintiff's negligence in pie sustaining injuries, and well after pie continued to be on Medicaid, which cost him kidney failure. So when we're looking at market value, it is well between $0 and those $100. When we look at the replacement value, Mr. Maffium tried to tell you on the stand today that pie is absolutely irreplaceable. There's no amount of number. However, we also heard that he purchased his new cat, Margaret, for $150. And finally, intrinsic value. Mr. Maffium tried to tell you that pie is worth as much as $1 million to him. However, we know that Samantha, the co-owner, settled for $150. Finally, Mr. Maffium is seeking to.
I thought she settled for 500.
Oh, excuse me, 500. That is correct, Your Honor. And finally, Mr. Maffium, the plaintiff, is seeking pocket expenses. He is seeking to be rewarded for the surgery and treatment, the bill for Pink Pearl emergency room, and the private cremation. This comes out to $7,015.25 plus the cremation. So, Your Honor, when you're looking at the value of pie, you're looking at between $0 and $500. And when you're looking at the pocket expenses, you're looking at $7,015.25 plus the cremation. Thank you.
Counselor, I have a couple of questions about Exhibit 2. Just relative to the actual inserts for the medication itself. In those inserts in Exhibit 2, you would agree with me that it indicates that it could be safe for use in cats younger than 4 months of age, that that cats that are younger than 4 months of age, it hasn't been established that it's safe. Would you agree with me that Exhibit 2 says that?
That's correct, Your Honor.
And Pie was roughly 4 months old at the time that your client prescribed the meloxicam to Pie. Is that true?
That's correct, Your Honor, but I would like to reemphasize what Dr. Volpes from the plaintiff mentioned herself, that if Mr. Maffium would have stopped giving Medicaid on day 2, there is no way that Medicaid would have been the cause of death.
During your client's testimony, there was discussion about the dosage that Pie was prescribed, correct? And at some point when your client testified, my recollection was that she had admitted that if the dosage that she had given to Pie had been taken through day 6, that it likely would have been too much. Is my recollection correct in those facts?
That's correct.
But Pie's owner did stop at day 5, correct?
That's correct.
So so the original prescription that was given for Pie, your client admitted would have been too much had there not been any signs of nausea or vomiting, correct?
Yes, that's correct.
So your client's original prescription for Pie was actually too much, according to the instructions and the insert, correct?
Yes, that's correct.
And you'd agree with me that that would be negligent to give a prescription for too much of a dosage for a cat, correct?
That's correct.
And Just touching on some of the blood work that was given to Pi prior to even the surgery or the prescription. Did your client actually perform blood work herself on Pi?
She did not, but she used the Humane Society's blood work, which was about 6 months old, so not too long. And she also did pull urine for analysis as well, which showed nothing abnormal at all.
You would agree with me that if you're going to prescribe a drug to a cat, when it's not recommended to do so, that pulling blood work yourself, your client should have done that rather than relying on old blood work. Would you agree with me that that would be the best practice?
I am not a medical expert. I feel like that would have been something that Dr. Volpes, the expert witness from the plaintiff, should have testified about. I cannot make that type of assertion.
But your client is a board certified practitioner, correct?
Yes.
And would you agree with me that a board certified practitioner should have taken her own blood work for the cat, especially given the fact that this medication is not FDA approved, especially in cats, correct?
Again, Your Honor, I cannot make that type of assertion or agreement.
Thank you.